All right, looks like we are live. I'm George. I'm one of the founders of Solo Suit. Good to see everybody today. Thanks for coming out to our webinar. We're going to be talking about how to respond to debt collection lawsuits, how to get those resolved. I have with me here Glenn Romano from Pennsylvania. Right, Glenn? Doing good. Good to see you. All right, Glenn. I'm just going to give a rundown on Solo Suit for everybody that's here, and then I'll give you, some time to introduce yourself and tell us about what you do with your work as well. All right, so most people on the webinar, you probably know, Solo Suit helps you resolve debt lawsuits or software program you can use on our website. You can use this to respond to a debt collection lawsuit, and then you can use this to settle the lawsuit as well. So a lot of people find us once they've been sued, and they use our software to get things taken care of. So let's go ahead and Glenn, let me make sure that the audio is working all right for you. Um, Glenn, go ahead and introduce yourself, will you? Hold on. Looks like the audio is not coming through for you for some reason. Let me try to figure this out. Let's see. Uh, Hold on just 1 second, folks. All right, Glenn, go ahead and keep on going. Let's see if it's working now. Yep, I can hear you fine. It just some people on the webinar are saying they can't hear you. So go ahead. Uh, Let me see. Yeah, it's working now. Yep, good. All right, continue on. Okay, great. Are you helping consumers primarily with debt collection and debt issues then generally? Is that right? Okay, great. Let's see. You know, Glenn, it sounds like they're saying there's audio issues still. This is weird. I don't think I've had this problem here before. Let's see. Um, all right, folks, trying to get the audio fixed here. Um, let's see what I can do. All right, let's Glenn go ahead and talk some more. Let's see if it's
Sure, George. Are you able to hear me fine?
I'm hearing you fine. Folks, let me know in the chat if you can hear Glenn. All right, Glenn, if looks like some people are saying they can hear Glenn now. Okay. Glenn, let's go ahead and dive into some of the questions. All right, folks, if you have questions, go ahead and put them into the chat. We use most of the time here to just respond to questions. So let's go ahead and do that up. All right. So we have from Frank. How do I remove a collection that was dismissed with prejudice by a judge from my credit report? I was never, not sure what's going on there. I was never notified of any actions taken by the collection agency, thus the reason for the dismissal.
I'm sorry, I don't understand. You said there was a judgment?
Yeah, Frank said, how do I remove a collection that was dismissed with prejudice by a judge from my credit report? So it looks like he had a lawsuit, then it got dismissed with prejudice. How do I remove it from my credit report?
Well, you can simply, write to the credit agencies and provide them with a copy of the dismissal, the order dismissing the case. That's, that should do it for you.
Okay, great. That sounds good. All right, folks. For anyone who missed what Glenn had said earlier for his introduction, he's a practicing attorney in Pennsylvania. He helps consumers primarily deal with debt issues. All right, so that's the quick rundown there. All right, we've got. Let's see. Got another question coming in here from Soldier for Christ. Also, when reviewing the complaint and documents, I'm not sure what this is. Okay, here we go. Soldier said, I know I'm early to the table, but really looking for an answer regarding the third-party collector that took me to court for a debt that they never did send me a letter or notification about this debt. When reviewing the complaint and the documents, the sales agreement and the bill from the original debt, it's all off. So I guess he's asking what he should do. Sounds like he never received like a debt validation letter or something before the lawsuit began.
Well, simply, you tell the debt collectors to stop harassing you, and you make sure that that's done through their. If they're calling you, make sure you get the message through on their voice recorder. It's also good to get their, find out who they are and get their address and write to them. If they continue to harass you, well, that's a violation of federal law. You could have a claim against the debt collectors. But if they send you a written collection notice, then you should respond that you want proof of the debt and who the creditor is, the primary creditor, before you can respond, because anybody can claim to be a debt collector. So you need to know what's going on and where the debt is coming from, if it's actually a real debt, or it could be, you may want to check with the credit bureau in case there's some identity theft going on. A lot of things can impact your credit out there and the debts that may be out there for you. So you really have to investigate where this debt is coming from and whether it's a legitimate debt, and then you can deal with it.
Okay, great. Yep, so you got to verify that it's a legitimate debt, so you can write to the collector, ask them to verify that. Sounds great. Thanks, Glenn. We've got another question here from Samuel. How do you determine what the statute of limitations are when the debt was sold to another company? So if a
Well,
debt
the
has been
stat,
sold from the creditor to a debt buyer, does that affect the statute of limitations? How do you figure out the statute of limitations?
right. The sale or of the debt or the assignment of an account to another uh, assignee or collector doesn't affect the statute of limitations. The statute of limitations starts to run when you're in default. So the last payment that you made, if you didn't make another payment, then whenever that payment was due and you didn't make it, that starts the statute of limitations when you're in default. So, and in Pennsylvania, for a debt, it's 4 years from the date of the default. So that's pretty much it. The transfer of the account has nothing to do with it.
Okay, great. So if the debt has been sold to someone else, that doesn't have anything to do with the statute of limitations, basically.
Right.
Alrighty. All right, we got another question from Sean. New question from Sean here. Sean's been sued by Discover Bank. He filed a motion to compel arbitration. What happens next?
Okay. In Pennsylvania, any lawsuit under $50,000 automatically goes to court arbitration, which is not the same as private arbitration. Court arbitration is conducted by the courts. Each county has a pool of attorneys. They generally pick 3 attorneys to sit as arbitrators, and they hear the case, the same as the judge would. Now, a precipice to compel arbitration is simply asking for a date for the hearing. If you're notified that a hearing date, well, depending on the county, you'll be generally given a list of attorneys that are available to sit as arbitrators, and if you object to any of them, then they'll pick another one. But eventually, they'll want to pick a date, and if they pick a date that's not convenient for you, you can ask for what they call a continuance, and a new date will be, out of courtesy, will be assigned. But you'll also need agreement or need to contact the attorney for the other side and let them know that you're going to be asking for a continuance. I hope that answers your question.
Nice. Okay. Yeah, that sounds great. I think that answers it right there for sure. Great. We got lots of questions. Just gonna go through kind of rapid fire here. Yahia, is judgment proof? Can that be a reason to dismiss a civil case? So if someone's
No.
judgment proof, okay. No, it's not.
No, judgment proof does not dismiss a case. There are plaintiffs out there, they want to get a judgment. Whether the judgment is worthless or not, that's not the issue. They want the judgment. The judgment's good for 5 years. Actually, the judgment, as long as they renew it, it's good forever. But if you ever become not judgment proof, then they can seek to collect on their judgment, execute what they call execute on the judgment. So being judgment proof is not a cause for dismissal. It gives you some comfort that they have nothing to get from you, and there are different ways that you can be judgment proof. I always go, actually, when I represent a client who's being sued by a creditor like this, one of the first things I try to find out is whether they are in fact judgment proof, because that determines what we're going to do. I mean, you have a plan for every situation, and I have a plan for clients who are judgment proof. And so it's just a strategy that we take with each lawsuit.
Okay, so judgment proof can be a thing. It is a thing, but it doesn't mean like the case is going to get dismissed because you're judgment proof. It can just impact what you do and why you do it.
Right.
Is that right?
Exactly.
Okay.
Yeah, it's not it has nothing to do with the substance of the case.
Yeah. Another question from Samuel. Can you please explain what latches means? Does this apply when they try to sue you for interest and costs and disbursements? I think he's talking about like the affirmative defense language, latches, equitable, estoppel, etc.
Well, it kind of works like a statute of limitations. However, the statute of limitations is a remedy at law. whereas latches is a remedy at equity. Now, what that means is that if the statute of limitations didn't apply, then the question is, did the plaintiff act when they should have acted to sue you? And if they didn't act, in an equitable situation, if they didn't act when they should have acted, then latches would apply. Now, it's hard to say when a court is going to apply latches in any kind of situation, but it's similar to a statute of limitations.
Okay, so it's similar to the statute of limitations, but it comes from like an equity court rather than a court of law. And an equity court, that's kind of like a holdover from like Great Britain times, isn't it? Pretty much.
In Pennsylvania, law and equity are merged. It's just it's where the theory comes from and how it's applied. It's applied equitable. It's another equitable remedy is unclean hands. And I'm not going to get into what that means, but again, these are things that have different meanings in different situations, and judges will apply them differently. So whereas a statute of limitations, it's written in law. You've got 4 years. If you're beyond the 4 years, you're out. And that's the way that works. Whereas equity is a more fluid situation.
Right. Okay. Great. Got another question from Maria. I filed a response and I got a delayed reduction order. What should I do next?
I'm not sure what she's talking about.
A delayed reduction order? I've never heard of that either. Yeah, I'm not sure, Maria. Maybe that's like a nuance. The reality is that there's a lot of courts in the U.S. They all do things a little bit different. Delayed reduction order sounds like just kind of a specific thing. Maybe that's exactly what it means. The delay of reduction, whatever was being reduced, I'm not sure.
Well, what state is she from?
Yeah, maybe tell us what state you're in. Maybe if you can tell us a little bit more about the document, we could help get a better answer for you. All right, we got Christopher. He said he was sued by Discover as well. Happened like 7 years ago. Walter said, "Can they come after my bank account? I'm in Texas." So maybe we talk about generally, can they come after someone's bank account, and then maybe Texas will know about it.
Yes, they can come after a bank account. What they would do is they would garnish the bank account, and typically that freezes the bank account so that you can't withdraw any money from it, and then they would have an action of garnishment with the bank to remove funds from that account. Now, there are certain things that you can do there are certain funds that are protected, such as pension funds, Social Security. They cannot be garnished. Also, wages cannot be garnished in Pennsylvania. Wages cannot be garnished against your employer. What that means is that a garnishment of wages means that a portion of your wages before it's paid to you will go to your creditor or your judgment creditor. That doesn't happen. But once you're paid and those funds from your paycheck hit your bank account, it's no longer wages, it's cash. And then they can, go into your bank account and at some point garnish it. That answers that.
Yeah. Yeah. And so when the creditor or the collector actually garnishes your bank account, that means they get an order. My understanding is they get an order from the court. The court requires you to send them your banking information. They contact the bank, and then they literally take the money out of your bank account.
Yeah, exactly.
Yep. One thing I'll note is that my understanding in Texas is that Texas is a little bit more restrictive on garnishment. So I think in Texas they may not be able to garnish your bank account. Actually, in pretty much any other state, they are able to. Darab, we got a question from Darab. I have sent an email with different settlement offers. They've never replied back. I've now received a letter of final judgment that I need to pay the full amount, which is $8,500. I can't afford a lawyer. I guess they're just looking for feedback.
Received a letter of final judgment. I don't understand what that means. You would get a order from the court or a judgment order that a final judgment has been entered. That would be a court document. That would not be in the form of a letter. If somebody's sending you a letter, I would question that as having any validity at all. But the thing to do would be that if you're concerned that there has been a final judgment entered against you, you could contact the court, and they would be able to verify whether or not there has been a judgment. Now, a final judgment is exactly what it is. It's final, which means you're too late. There's nothing you can do about that, unless it was. There is a way you can open a judgment, but it's we go back to the issue of equity. It has to be timely, and so and there are different rules on what's timely. Uh, Generally, it's 10 days from the notice of the judgment, but again, I can't see what you're looking at, so I really don't know if you're actually looking at a judgment or some kind of threat of a judgment. It's,
Yeah.
you know,
So usually, yeah, we see this sometimes with consumers. So what a judgment from the court will look like is it will usually say order for final judgment, right? And then it will also be signed by the judge, and it might even have a seal like this or stamp on it. Is that right, Glenn?
yeah, would
Yep.
be correct.
And sometimes you might receive something from a collector that looks like that, but isn't quite that. So they might receive something from a collector that is like a proposed order, but it hasn't actually been signed by the judge. You might receive, in this case, maybe like a letter that isn't actually a court document at all, that is just something else. Um, and then, Glenn, kind of getting to this person's other question, and then we're wrapping up here at half past the hour, folks. So this is maybe one of the last questions we'll take. Is Glenn, if a consumer's tried settling with a collector, and the collector doesn't respond to the consumer, can the consumer somehow leverage that in a case, in a hearing?
No. Evidence of settlement negotiations are not um, uh, they're not considered evidence in a court, and the court won't entertain any evidence of settlement negotiation, unfortunately.
And a judge won't care if one party tried to settle but another party wasn't willing to. They wouldn't consider that like bad faith in your experience.
I consider that at all.
Okay. All right. Well, let's see if we have. Let's see. Folks, there's a ton of great questions in here. A lot of people on the webinar today. Very glad you're all here. Hannah's trying to respond to all of your questions in the chat through text. It's our wonderful assistant, Hannah. She does a great job. If we haven't gotten to your question verbally or in the chat, feel free to email us or come back next week. And we do the webinars about weekly. We're always here rooting for you guys. Glenn, I assume people that are in Pennsylvania are welcome to reach out to you.
Yes,
any
absolutely.
final words from you?
Well, if you're contacted by a creditor and you feel you want to settle outright, do not contact them and say, "Hey, I can pay you $100 a week." Never do that. First, get a number. First, settle on a number. If they're coming after you for $5,000, whatever you negotiate, whether it's $3,000, $2,000, $4,000, get that number first. Then figure out how you're going to pay for it. That's the best I can give you on that one.
That's great.
And if you settle it, come to Solo Suit. We'll help you out.
Happy to help you out. Glenn, if people want to reach out to you directly, what's the best way for people to reach out to you?
Yeah.
Like a website, email, phone,
reach
something?
out through email. That would be the best way.
Okay.
I can give you my email here, or
Sure.
do you want to? Yeah, my email is Glenn, GLENN, at Glenn Romano. That's one word. BLENNROMANO.com. Okay, and feel free to shoot me an email on any of your questions, and if I can answer it, I will.
All right. Thank you, Glenn. Very glad to have you on the webinar today.
It
Thanks
was
for all you
fun.
do. Thanks for helping out the consumers, helping out the people. And always remember, folks, we are rooting for you. We want you to win.